The first thing we do, let's kill all the lawyers. Yes, Justice Vinod Chandran quoted William Shakespeare before penning a crucial judgment on the last day of October this year. Hello everyone, I'm Devojit Das and today we are breaking down a Supreme Court judgment that is, of course, crucial for every lawyer or aspiring lawyer, but also really important for every concerned citizen. Before we jump into the legal principles, you might need to know how we reached here in the first place. This started after the Enforcement Directorate issued summons to two senior advocates, legal giants Arvind Dattar and Pratap Venugopal. Shortly after, however, the ED later withdrew those summons following protests from the bar, even issuing a circular that future summons to lawyers would require prior permission from the director. But the controversy did not end there. A bench of Justices K.V. Vishwanathan and N.K. Singh later expressed concern over the growing trend of police and investigative agencies summoning advocates for the advice they give their clients. The bench observed that such actions could undermine the independence of the legal profession and, by extension, the administration of justice itself. Following that intervention, the matter was referred to the Chief Justice of India and the case was officially registered on July 4th of 2025. Now focusing on what actually happened inside the courtroom. When the matter reached the Supreme Court Bar Association, the Supreme Court Advocates on Record Association, and other bar bodies made strong submissions. They argued that no lawyer should be summoned without a prior magistrate's approval and that it should not be automatically assumed that legal fees are proceeds of crime. Senior advocate Vikas Singh even drew a comparison with a Jacob Matthew case on medical negligence, suggesting that just as FIRs cannot be registered against doctors for medical negligence without a preliminary examination by an expert committee that consists of doctors, lawyers also require an independent body of such professionals which would at least screen frivolous FIRs. However, the government opposed this. Solicitor General Tushar Mehta argued that such a rule would create a special class of protection violating Article 14's equality principle. He maintained that if a lawyer is directly involved in a crime, they cannot hide behind privilege. Attorney General R. Venkatramani also opposed a magistrate's oversight, warning that it would give a long rope to those misusing the system. In other words, too much freedom for bad lawyers. Adding to that, it was also argued to the Attorney General that in-house counsels might end up claiming the same privileges as practicing advocates. Now let's get to what the court had to say. The bench led by Chief Justice of India B.R. Gavai and Justice K. Vinod Chandran issued detailed guidelines regulating how lawyers' documents and devices can be handled during investigations. The court clarified that documents belonging to a client, even if held by a lawyer, are not protected under Section 132 of the Bharatiya Sakshya Adhiniyam. This provision confers a privilege on a client that would stop an advocate from disclosing any professional communication. This is important right here. Documents belonging to a client not protected under this section. However, the court emphasized that strict procedural safeguards must be followed before such material can be accessed. In criminal cases, any direction to produce client-related documents must go through the court under Section 94 of the Bharatiya Nagrik Suraksha Sanhita that places a mechanism in place for summons to produce documents or other things, and this has to be read with Section 165 of the Bharatiya Sakshya Adhiniyam that sets down the same mechanism under evidence law. That, as per the court, ensures judicial supervision. In civil cases, production will follow again Section 165 of BSA, evidence law as mentioned earlier, along with Order 16 Rule 7 of the Civil Procedure Code that codifies the power of the court to demand any person present to produce any document then and there in their possession. Importantly, once such documents are produced, the court must hear both the advocate and the client before deciding whether they can be admitted as evidence. Another significant part of the ruling dealt with in-house counsels. The Supreme Court held that communications between in-house counsels and their employers are not covered by attorney-client privilege under Section 132 of the Bharatiya Sakshya Adhiniyam, since in-house counsels are not considered advocates under the Advocates Act 1961. The court drove this point home by citing Rajneesh KV versus K. Deepa, a constitution bench decision starting at page 64 if you're interested in reading that specific portion. After excluding in-house counsels from the club yet again, however, the court clarified that communication between an in-house counsel and an independent legal advisor to the company will be protected under Section 134 of the BSA, which states that no one will be compelled to disclose any confidential communication between them and their legal advisor unless the person offers themselves as a witness. Distinguishing between practicing advocates and company lawyers, Justice Chandran noted that while in-house counsels do advise their employers on legal issues, they are ultimately bound by their employer's commercial interests. The court observed that such counsels, and I quote, would always be beholden to their employer and obliged to protect their interests. Justice Chandran's 78-page judgment also offered a broader reflection on the purpose of legal privilege. Referring to Section 126 of the Old Evidence Act, now Section 132 of BSA, the court said the provision exists to protect advocates from being bullied by investigative agencies into disclosing confidential client communications. The court called it a safeguard for the majority of honest lawyers who uphold the justice system, while acknowledging that a few occasional black sheep may exist within the profession. Quoting the judgment here, the provision providing protection to privileged communications is not to protect those deviants, but to ensure that the vast majority involved in the task of administration of justice are not victimized or bullied into disclosures merely for having represented a client of questionable conduct. In short, just because the client is questionable doesn't mean the lawyer is. And that is why Section 132 exists. Finally, the court stressed that Sections 132 to 134 of the BSA serve as an immunity not just for clients but also for advocates themselves. Parallelly, it also reminded lawyers of their duty under Rule 11 of the Bar Council of India rules to protect client communications as far as the law permits. Important judgment, important ramifications. For more of this on every important issue that the courts are grappling with, visit livelaw.in and follow us on all our socials to stay updated with everything that is law.